Welcome. I just wanted to do a quick video update of our case called Walker versus Putnam County. It's the infamous AR-15 open carry legal battle that's currently taking place at the U.S. Fourth Circuit Court of Appeals. And tomorrow just happens to be the deadline when our opening brief is due. So if I look like I've been up since early this morning staring at a computer screen, reading and writing, it's because I have. And there's nothing like an entire day of writing about gun rights and reorganizing your sentences over and over again to really get you thinking about the importance of gun rights. This case arises out of Putnam County, West Virginia, and my client is a guy named Michael Walker. And if you haven't seen the original YouTube video that I posted on this case, it's got, it's got 100 and something thousand views on it. And it's something that Michael had filmed himself when the incident happened. To make a long story short, we filed a federal lawsuit over what's shown in the video. We got up until about a week before trial or so in federal court, and we lost the case basically at the trial court level. So then we appealed it to the U.S. Fourth Circuit Court of Appeals, and I'll explain why. Hey, Lenny, thanks for watching. I think there's a way. This case, it involves two different important things. One is the right to open carry a firearm in an open carry state, such as West Virginia or North Carolina. And secondly, it involves whether so-called AR-15 style rifles should be given an unequal, a separate and unequal analysis in the federal courts than you have for other types of firearms. So the existing law that we're battling over here comes out of a case called the United States versus Black from 2013. And that case says that if you're open carrying a firearm in an open carry state such as West Virginia, police officers cannot stop, detain you, and run a criminal history background check on you just by virtue of the fact that you're in possession of a firearm, because that's perfectly legal in a state such as West Virginia. So therefore, that cannot legally be reasonable suspicion that you have been involved in some sort of criminal activity. So that is really one of the most important gun rights cases that we have here in the Fourth Circuit. And the Fourth Circuit just refers to the federal appellate court for Maryland, West Virginia, Virginia, North Carolina, and South Carolina. So if you live in one of those states, you're governed by the law that comes out of the Fourth Circuit. And if a United States Supreme Court decision overrules the Fourth Circuit, then of course you're governed by that one. But usually we're dealing with Fourth Circuit case law a lot more than the United States Supreme Court. So what a lot of people don't realize is that Fourth Circuit federal law, it really governs everything about actual gun rights if you live in one of these states, such as West Virginia. We like to refer to our Second Amendment rights. In reality, however, the United States Supreme Court has not even extended application of the Second Amendment beyond our homes. And it took them a long time to do that. But as of right now, according to the United States Supreme Court, you only have a Second Amendment right inside your house. And they haven't even applied that to, for instance, AR-15s yet. They applied that in the context of handguns. So there's a lot of litigation yet to come in the area of the Second Amendment. But that means that there's not much for us to rely on when it comes to Second Amendment rights. So in reality, most of our rights, most of our cases to protect our rights. Now, of course, the right to bear arms and the right of self-defense is one of our natural rights, are supposed to be inalienable rights that's preserved by our constitutions. But when you're practicing law and you have to point to the deprivation of a civil right in order to file a lawsuit, we generally have to point to, most times, the Fourth Amendment. So in practice, the Fourth Amendment is basically the white knight of the Second Amendment. It's what protects our gun rights. So just like the Fourth Amendment protects other types of activity, that's what we have to rely on for gun rights as well. So you look at the Fourth Circuit case law or the United States Supreme Court case law to see what the federal law is in regards to, when the police can stop you, when they can't stop you, and when they need to get a warrant, when they don't need to get a warrant. So what it came down to in this case is we're looking at the open carry of a firearm in West Virginia. So the existing law as of 2013 in the case of United States versus Black has been that just because a police officer sees you openly carrying a firearm, that alone, without more, does not give them the right to stop you and perform what's officially known as an investigative detention. They can't stop you and get your ID and run a background check. Now, why would police want to do that? Because they may think that you're a prohibited person, and that just means a person that is not allowed to possess a firearm, such as a convicted felon, somebody who was convicted of domestic violence, or somebody who had been committed to a mental institution, and there are a few more. So those are known as prohibited persons. So if a police officer knows who you are, they know that you've been convicted of a felony, and they see you in possession of a firearm, then that's going to be reasonable suspicion to stop you. If they don't know you, they don't know you from Adam. They don't know whether you're a convicted felon or not. So in that sort of situation, if you're carrying a firearm that's legal in a particular state, such as West Virginia, and which is pretty much any firearm, because you wouldn't be able to tell at a distance whether it could be one of the few types of firearms that would not be legal in West Virginia, and even those you could have a permit for. And I'm talking about machine guns, really. But it's legal in West Virginia to open carry a pistol, a shotgun, an AR-15, and that's what we were dealing with in this case. My client, Michael Walker, had an AR-15, and when I say that, I mean an AR-15 style rifle, because the phrase AR-15 is really a misnomer. So a lot of people think that AR stands for assault rifle. First of all, assault rifles under according to our own government, really are only select fire weapons, so machine guns, fully automatic weapons. So what we would refer to as an AR-15 is not an assault rifle, but that's another video. So AR stands for Armalite, which is the company that was the predecessor of Colt, that first made these rifles, and they called it the AR as in Armalite, and that's what it stood for. And then the first AR-15 was a fully automatic machine gun, which became, once it was adopted by the military, the M16. So the first AR-15 is really the AR-15. Now, we refer to AR-15s as really what's called an AR-15 style rifle. It looks like it, but it's not select fire. It's not fully automatic. So, but in any event, they're legal in West Virginia to open carry, just like in Virginia. So my client was walking down the side of the road, and he had an AR-15 safely strapped on his shoulder, and he also had a backpack strapped on top of that. And he was headed coyote hunting. And Michael suffers from epilepsy, so he doesn't have a driver's license. So while he was walking, he got confronted by law enforcement, as had happened to him before, and he knew that they were about to harass him. So he pulled out his camera and he started to take a Facebook Live video. And if you've seen the YouTube video, you can see exactly how it went down. I believe that I can do this here. Let's see. This should work. Now let's try the other one. All right, there we go. All right, so that's when he's first walking there. And
have I broken any laws?
Deputy Donahoe walks up and asks him for his ID. He says, "What law have I broken?"
Can you tell me what crime I've committed?
Can you tell me what crime I've committed? And he keeps asking for his ID, and he's asking for his ID because he wants to go run his run the background check with dispatch and see if he is a prohibited person. That's exactly what he's trying to do.
Sir, I'm just trying to get up to my destination.
So there were supposedly 911 calls, as there many times are with people who open carry firearms. You know, we go back to the phrase "freedom is scary." Well, there are a lot of Karens out there who they'll see a man with a gun. Oh my God. And they call 911. There's a man with a gun. Well, the problem is, and hopefully law enforcement officers realize that, well, I'm sorry, ma'am, you know, if he hasn't done anything wrong, that's not illegal in West Virginia. That's perfectly legal. So I don't know. I don't have any knowledge of any 911 allegations that alleged he did anything wrong or committed any crimes. He was just a guy walking down the side of the road with a gun, and he was heading coyote hunting.
Okay, is that against the law?
Everybody in the world is going to call.
And so now he's challenging them on the law, and he's actually correct. He's actually correct that, you know, what law have I broken? What crime have I committed? And Deputy Donahoe is telling him that, no, you don't understand the law. I can get your ID. If I ask you for your ID, you have to give it.
Then why am I getting stopped?
But the issue is whether or not the initial stop itself was legal, because there has to be reasonable suspicion. And again, as I'm pointing out here on the screen, if you read the case of United States versus Black, it's in a civil rights context. It's written by Justice Gregory of the Fourth Circuit, really one of our greatest civil rights supporters. You know, that has written some great decisions from out of the Fourth Circuit, and he knows, and he mentions that, you know, gun control was used to subjugate, you know, the black population in the South in the Jim Crow era. That's where a lot of gun control laws and statutes, especially out of North Carolina, for instance, came from.
Yes.
Yeah, Troy, there's Troy's comment. He's exactly right. If we fast forward the video here, it's really, this is really an egregious part. They keep arguing and arguing.
Don't touch me or my
I'm
property.
looking, I'm just seeing what kind
Don't
of gun
touch
you got,
me or
brother.
my property.
Anybody to do their damn job out here. I'm just wondering what you have. I'm not going to take it from you at this
It
point.
doesn't matter what I have. I'm not breaking any laws. I'm not committing
Listen
any
to me.
crime.
I like guns too. I'm just kind of curious what you like to carry. I'm making small talk. Okay? You can do this bullshit all you want. And I fucking can't stand cocksuckers that do this kind of shit that make it more difficult. I don't have to answer questions. You know what? That's all I hear all goddamn day.
That's not my fault, sir.
It is your fault.
No, it's not.
Because you cocksuckers started. I ask you for ID. When a law enforcement officer asks you for ID, it's not, I don't have to provide it. It's, here it is, sir, because by law, you fucking got to give it when you are asked for it.
All right. So, I mean, that's it. A police officer calling a law-abiding citizen a cocksucker, and he has to give him, if he asks for his ID, he has to give it. And the funny thing is you know what, his lawyers, the way they had to defend him, the way they won the case was to argue in court that basically he didn't know what the hell he was talking about. And that police officers are allowed to be wrong. That's why we give them qualified immunity. We don't expect them to be that smart, really. We don't expect them to know the law. And that's actually what the court decision said. It's, you know what, that we look at an objective standard. So it's not a subjective standard. So even if the police officer is a complete idiot, the standard is that of an objectively reasonable police officer. So it's just what a theoretical, not a perfect police officer, but a regular, reasonable police officer, what would he have believed to have been the case? What facts was he presented with? So the court and his lawyers tried to avoid all of this stuff, where he basically admits on the video that he doesn't know the law and that he's violating the law. So, but when we go to hold him accountable for that in court for this civil rights violation, it's not a criminal case, it's a civil lawsuit. So we have to show that an objectively reasonable police officer would have known that what they were doing was depriving somebody of a civil right. So would an objectively reasonable police officer have known that there was no legal justification for that stop? I mean, there has to be, right? If the law of the land is USV Black and it says you can't stop people who are open carrying firearms in order to run their ID to see if they're allowed to possess a firearm, you're not allowed to do that. But that's exactly what he did. You can see it on video, and he admits to it about 5 or 6 times. And he goes on to say that I do it all the time. I do it every day. That's what he said. And so the court had to rule and did rule that, well, he didn't know what the hell he was talking about, but the objectively reasonable officer still could have had reasonable suspicion based on something completely unrelated to that. And so what the court ended up going with is what the Putnam County lawyers were advocating, and that was, the scary black rifle, the evil AR-15. You know what the defense, I mean, you can watch that whole video, and there's nothing in it about any school at all. And so what they came up with, because clearly it was in violation of USV Black, what came up with, or what this deputy came up with after he lawyered up, by the time we filed the lawsuit and we got to his deposition, was he said, well, Michael was walking in the direction of a school. There was a school about a mile down the road. In reality, Michael was walking to his buddy's house and they were going coyote hunting. And it was about 6:00 p.m. in the evening. And there was no mention of a school. And after the deputy eventually let him go, Michael continued to walk in the direction in which he had been walking. And this deputy never even followed him, never even looked to see where he went, and never asked anybody else, including the other deputy who was present, to go see where this guy was going. But that's what actually happened. But the defense that they came up with after the fact was, well, there was a school in that direction about a mile down the road. So his hindsight, his new theory that he comes up with after he clearly misunderstood the law. It was clearly a case of a mistake of law. So after he gets lawyers, now he's concerned that, well, this is shortly after the Parkland school shooting, and an AR-15 style rifle was used in the Parkland shooting. So now I'm testifying that I was concerned he could be a copycat school psychopath shooter, like Nicholas Cruz from the Parkland shooting. So that's what he actually testified to at his deposition. There was no mention in that video of any sort of a school shooting, of any concern about a school. And probably part of the reason is because it was 6:00 in the evening. And unfortunately, I didn't find that out until probably, a little too late. And the officer had testified that school was in session. That's what he said during his deposition, that school was in session. And so he suspected that he had committed, or that he could be a school shooter. So then later I find out, wait a minute, it was 6:00 p.m. when this happened. And if you go back and watch the video, yeah, you can really tell that it's in the evening. And I think you can hear the crickets start to come out. And hell, I even researched that and brought evidence to the court that, well, if you hear crickets, the science says that it's going to be dusk. It can't be morning. So clearly school was not in session. It was 6:00 in the evening. It wasn't true that school was in session. And the reason why school wasn't mentioned is because it had nothing to do with it, absolutely nothing to do with it. But that's what the defense came once the lawyers got involved. And that's what the court ended up ruling on, is that, well, even though it's legal to possess an AR-15 in West Virginia, and even though open carry, including AR-15s, is legal in West Virginia, when we combine that with the fact that there was this Parkland shooting that used an AR-15, and that an AR-15 is dangerous, and that an AR-15 is not traditionally used for hunting in West Virginia. And that is what the court order said. And it's not true. It ruled that AR-15s are not used for hunting in West Virginia. And you combine that the officer basically could use the fact that it was an AR-15 and that there was a school in that direction as reasonable suspicion to stop, call him a cocksucker, take his ID, lecture him, and so on. You can watch the video. And I don't know if it's ironic, but can you believe that with everything we've seen recently with the police, and they've been putting it in a racial context, and if you've been involved, if you've lived in West Virginia and you've looked at this at all, you know that there have been problems with law enforcement that have absolutely nothing to do with race. And Michael Walker is a white guy, completely white. And you can see how he was treated by a white cop. It had nothing to do with race. It had to do with the institution of a police state and 5,000 plus different criminal laws. That's the environment that we've lived in. And this wasn't the first time that Michael had been harassed because he didn't have a driver's license and he had to walk. If he wanted to go coyote hunting, he was walking there. So we end up with a court order, and I wasn't looking. This was not this wasn't necessarily, we weren't hoping to take this issue up. It was just a clear-cut civil rights violation and a gun-related civil rights violation. So I wanted to take the case. And I moved, I thought we had to win under the law. I mean, we have a Fourth Circuit case directly on point saying that was an unjustified stop and seizure. I mean, yeah, he didn't have a whole lot of damages from it, but it was a civil rights violation. And under federal law, if you can prove that, then you're entitled to get your attorney's fees if you sue over it. So even if we had $1 of damages, we would get all of our be entitled to all of our attorney's fees and expenses. So we figured that we could prove the violation because it's directly what United States versus Black, the law of the land since 2013, says that a police officer cannot do. But somehow we get a court order out of this at the urging of Putnam County, their lawyers anyways. And this was the first county in West Virginia that declared themselves to be a so-called Second Amendment sanctuary. But we get out of their arguments a court ruling that says, AR-15s aren't used for hunting in West Virginia. And I'll just point out that the West Virginia Constitution says that we have the right to keep and bear arms for the purposes of hunting, recreation, and the defense of self, family, home, and the state. So West Virginia's our Constitution says that it's not just about hunting. It's about recreation if we want to. It's about protecting ourselves and other people and our state. So it doesn't limit our rights under the West Virginia Constitution and West Virginia law are not limited to hunting. It has nothing to do with hunting, even if we're going hunting. And they don't distinguish between the AR-15 style rifle and a shotgun. And that was actually brought up in court is, well, a shotgun would be different. Well, how the hell would a shotgun be different? And what's the legal precedent for treating an AR-15 different than a shotgun? There is none. I mean, it's bringing in completely extraneous stuff that wasn't involved in what you see in the video. It had nothing to do with it. Now, if you watch the video a little longer, you'll see that the officer did, before the conversation ended, he said, well, why do you need an AR-15? Why are you walking around with an AR-15? Who needs an AR-15? And it just demonstrates that, the reason why we took the case to begin with, because the AR-15, and people don't want to admit it, if we're going to call it that. I mean, it's the most popular, widely owned firearm in America at this point. I brought up a lot of these statistics and am citing them in our brief, but it shouldn't even have to come up. But now it has come up, and now the issue's going before the Fourth Circuit, where they're going to decide whether or not a federal court can treat an AR-15 with less deference under the law than a shotgun or a pistol. Because right now, they have to defer to state law. West Virginia law is that we can open carry AR-15s, whether anyone likes it or not, whether Putnam County likes it or not. And they can't see somebody open carrying an AR-15 and decide to stop, harass them, call them names, or even just politely run their background. They're not allowed to do it. So has this been appealed to a higher court is a question. Yeah, that's what I'm talking about. It's before the Fourth Circuit Court of Appeals in Richmond, Virginia right now. So that's just one step below the United States Supreme Court. And our brief is due tomorrow. We'll have it filed tomorrow, and I'll put that up on our website, which is our blog website. My regular website's johnbryanlaw.com, but my blog site where I put all this stuff is thecivilrightslawyer.com. So you'll be able to read it there by tomorrow afternoon. But if you live in West Virginia or North Carolina, all open carry states within the Fourth Circuit, then this case is important to you. For instance, if I lose this case, and I wasn't setting out to do this, but say I lose this case, next time there is a peaceful protest at the Capitol in Richmond where hundreds or thousands of law-abiding patriots show up, open carrying AR-15s strapped on their back, which really is First Amendment speech as well, as in addition to just exercising their rights. What could Governor Northam do then? He could order his state troopers to go seize anyone or every one of those individuals, to forcibly take their IDs and forcibly run background checks on all of them. Right now, what's stopping him from doing that, which I'm sure he would have? Well, United States versus Black. It says that they can't do that. And, you know, the Judge Gregory, who wrote the decision of USV Black, as well as other decisions, he is a Black American. And I've argued before him before, and I've listened to others of his arguments or of his cases that he's presided over, or he's been on the panel for. And he sees things, he correctly sees the gun rights issues through the lens of broader civil rights issues. Because police officers, for instance, in North Carolina, can go into a predominantly Black neighborhood, and they allowed to just see, even though open carry is legal, if they see a Black guy in a Black neighborhood, which they call high crime, with a pistol strapped to his waist, can they just assume that he's up to no good, that he's involved in criminal activity just because of his skin color or the skin color that's predominantly in the neighborhood? No. Have they done that? Yeah, hell yeah. And that's why Judge Gregory wrote the opinion he did in U.S. versus Black, because it's a civil rights issue. There's a law student I know who is getting this new law review article he wrote published, and it's not published yet, but I'll put a copy of it when it's published on my blog. But I've seen the draft of it. It's a great article, but he goes all through these laws from North Carolina, all these pistol permit laws. They were all Jim Crow era laws where the white sheriffs were able to keep guns out of the hands of their Black citizens. And that has carried through with a lot of these Fourth Amendment cases, is that police officers, I mean, if they're allowed to just see the gun, they could stop a guy based on the color of his skin just because he had a gun, whereas they could not stop a white guy. So I mean, it's very much a civil rights issue, and Judge Gregory recognized that, and he really wrote a great decision in U.S. versus Black, and it doesn't just protect any one minority; it protects everybody. And it was supposed to protect Michael Walker. And obviously that had nothing to do with race, but it does have to do with civil rights. So you have a police officer that thinks he can stop and get the ID of anybody he wants when the law says that he can't. So you always have to look at these things in the context of even if you wouldn't do that, if you allow a police officer to bend the rules in one situation, then you would be a hypocrite to expect the rules to be followed in your situation in the future. So to make a long story short here, we are filing our brief tomorrow, and even the Fourth Circuit panel that hears this appeal, they don't have the option under our laws to overrule U.S. versus Black. Now, the United States Supreme Court could, and the Fourth Circuit, if it's sitting on banc, could, which means all the judges of the circuit. Usually it's just a 3-judge panel that decides these cases. And then if one of the parties doesn't like the decision, they can request a hearing on banc, which means all of the judges. Now, if that occurs, then they can overrule U.S. versus Black. And that's the state of the law in the Fourth Circuit right now. So until that happens, stare decisis applies, which means that the Fourth Circuit won't have any choice but to follow the legal precedent of United States versus Black. But, the district court didn't follow it. And if you read the district court opinion, the court said, what was the wording? The court said that since states have been liberalizing their open carry laws, that this is a developing area of the law. So it's saying, yeah, we acknowledge that USV Black is the law, but with the increase in open carry rights, it's a developing area of the law. Therefore, the officer should be able to consider, the AR-15 being scary, and that there was a school in the direction that he was walking. So we'll see what the court does. But if we lose this case, then USV Black means nothing, because there always can be some theoretical or speculative crime that one could commit with a firearm. So, either you can stop somebody because of the presence of a firearm, or you can't. Because if all it takes is to come up with some after the fact theory about a crime that man could have committed with that gun, then you have no rights. Because no matter where you are, what type of gun you have, he could just say, yeah, well, I was afraid he was gonna take a left turn and go into a 7-Eleven and shoot up the place. Or, there was a house a couple hundred yards away, and he could have gone in that house and shot everybody inside the house. So, you could always come up with some, theoretical fear of what somebody could do with a gun. But freedom is scary. We either have freedom, even though some people are scared, or we don't have freedom. So after we file our brief tomorrow, then they'll have another month, about another 30 days, and they'll file their response brief. Also, during this period of time, it might be that Gun Owners of America files what's called an amicus brief, which is a friend of the court brief. And that would be just another brief from that organization in support of our side of the case. And it would have been nice if the NRA showed interest in this, but apparently the Gun Owners of America organization right now are really the ones who are proactive in getting involved in a lot of these cases. And they may not be able to do it because they have so much going on with all the coronavirus stuff right now, or at least their lawyers do. So I know they're busy with that stuff, and that they may not be able to get to it, but they've definitely expressed their support and their desire to do so. So hopefully the case goes well, and the people in Putnam County, West Virginia, realize that their law enforcement and are pushing for a restriction of their gun rights. It's hard to believe that on the one hand, they declare themselves to be a Second Amendment sanctuary, And then on the other hand, in court, they're quietly calling the AR-15 this evil implement of war, when the average citizen in West Virginia probably owns one. And they didn't buy it as an evil implement of war. Who cares why they bought it? They can hunt with it. They can use it for self-defense. They can buy it as an investment, which probably wouldn't have been a bad idea with the gun market right now. So if there's any other questions, if they rule against it at the Fourth Circuit, can it be appealed to the Supreme Court? Will they even address it? You have the right to appeal to the Fourth Circuit, but I'm sorry, to the Supreme Court, but they get, you have like a 0.00 whatever chance of getting your case accepted to the United States Supreme Court. And it's a big pain to actually ask, because you have to have umpteen copies of everything printed for them. And maybe they're relaxing those standards now with everything that's going on, but I'm not sure. So, it's difficult to ask because then it costs a lot more, and it's really a Hail Mary anyways. Courts quit ruling by the law a long time ago. They rule on emotion, their own political ideology. Yeah. Legislation from the bench is, it is a big problem, and it continues to be a problem. And this is one of those gray areas, or it is a gray area. It's the major gray area that we don't really talk about much, but it's sort of a no man's land, because, you have judges that are generally good on civil rights issues and generally good on the Fourth Amendment that may not see things our way in this case, because it involves guns. It involves gun rights, and they're not, they're not that way on the Second Amendment. And it's just like on the other side, so the liberal judges are good generally on the Fourth Amendment, and then the conservative judges, for instance, Scalia, he was good on the Second Amendment issues, but he was terrible on the Fourth Amendment issues. Now, why? I don't know. You either, in my opinion, you either strictly construe the words, the text of the Constitution and the intent of it, or you don't. So, I don't see how you argue that there's no constitutional right to abortion because there's no mention of abortion or the so-called right to privacy in the Constitution, but then you don't also, apply the Fourth Amendment to somebody who has pot in their car or in their house. I don't differentiate those two things. Either you are pro individual right or you are pro government rights. It can't be both. I don't see any difference between the Second Amendment and the Fourth Amendment. But I'm not a law school professor or an academic of some sort that would ever be considered for any of these judgeships. So I'm not sure how they get to the positions that they do, but it comes with having a certain ideology, I guess. And the way the ideologies have panned out is, if you're a conservative judge, you're pro individual on a lot of things except for the Fourth Amendment. You're pro police. Why? I don't know. And then the liberal judges, you're pro individual on the Fourth Amendment. So you side against the police generally and in favor of individual rights, unless those rights have to do with the Second Amendment. In which case they rule against the Second Amendment every chance they get. Has the goof who works at the Putnam County Courthouse and threatened me? Yeah. So you remember that. I don't know. After after that happened, I met with some of the senior deputies there in Putnam County, because in that other case, they did supposedly an internal investigation at the direction of the sheriff. And, we cooperated with them, gave them everything. And the funny thing is as far as I know, they did nothing in that case, internal wise, just like in this case, they didn't. I mean, you'd think that, how many of you have jobs where if you called somebody at your job or a customer or a boss or whatever, if you called them a cocksucker, especially now when everybody's offended at everything. Hell, isn't that like homophobic? So, you call somebody a cocksucker at your job. How many of you would get fired? Probably everybody would get fired. Or even if you said it on social media now. So here you had somebody who treated a citizen that way, and nobody cared other than just other citizens. As far as I know, no discipline whatsoever. It's not like he was baiting him and or trying to get him mad. Sometimes some of these YouTube guys they'll go get up in officers' faces and just try to get them to lose their temper. And I can kind of sympathize with that sometimes. A lot of us, none of us are perfect, and anybody's capable of losing their temper if pushed. I can see that. If you're poking them, you're pressing their buttons. But here, my guy was just walking, trying to go his own way. He asked several times if could he go? Was he free to leave? And it was the officer who was keeping him there. And all of a sudden now he's the cocksucker and calls him a sovereign citizen, which he wasn't. And that came from nothing. And they did more than that too, which really wasn't shown in the video. After this happened, there was basically an APB type deal on the West Virginia Intelligence Exchange that was put out and circulated to all law enforcement in West Virginia, which they have kind of their secret, it's basically like a secret email group where they send little dossiers on individuals that they think are dangerous or whatever. And so they sent one out on Michael to all the law enforcement groups, basically stating that, he's a known sovereign citizen type and he's known to be armed at all times and he's to be considered dangerous and so on. And when I took the depositions, they all said, oh, I don't know who did that. I didn't do that. I don't know who did that. Well, where'd that information come from? I don't know. I have no idea. So no one really, this particular guy didn't own up to having any involvement with that, even though he was the only one who interacted with him. But what is the reason they did that? I would speculate that therefore next time they had an encounter with Michael, they would just go ahead and seize him first and disarm him. And then they could say, well, he was known to us as being potentially dangerous. And then they could cite that intelligence report is my theory about why they did that. But far as I know, they never bothered him again after that. But of course, I also sued them and brought all of this out to light just by putting it on YouTube. Let's see. Yeah, Ray, that's kind of what I was just talking about, that a lot of the Jim Crow laws in North Carolina and elsewhere in the South, had to do with suppressing the black population. And, wouldn't that be funny if a lot of the race pimps who are out there now, using that issue for their own political gain, that would be a good question for somebody to ask them. Like, all right, there's documented history that gun control laws, for instance, ones that are still on the books in North Carolina, have been, were a product of Jim Crow. They were Jim Crow laws from the Jim Crow era, used to suppress gun ownership by black Americans. Shouldn't those laws be thrown out? Shouldn't the guys who made those laws, shouldn't we take their names off of any public buildings? If they have statues, tear their statues down, erase their names from the history books. And I bet you think that they would be outraged over that? Do you think that they would be for any gun control, even Jim Crow gun control? I doubt that. I think you'd see the hypocrisy show through if you brought out these Jim Crow issues, but they were very real. And if you read any Fourth Circuit decisions, read the writings of Judge Gregory. I mean, he's not a conservative. He's not known as a conservative judge. He was appointed by a Democrat, but on these civil rights issues, I mean, he has the background to give context to why they were important. And for instance, I've heard him say during oral arguments before that, there was a case with the Fourth Circuit where police showed up to a trailer in a trailer park, and a guy, they didn't have their lights going. They didn't announce themselves well, and they walked up in the darkness, and this guy stepped out on his front porch with a shotgun. And I don't remember if he shot one of the cops or they shot him or both. I think he did get shot, but Judge Gregory said, well, hell, when I was growing up, if my dad heard something outside the house, he's going out on the damn porch with a shotgun too. And we have every right to do that in America, in the Fourth Circuit. And so they actually decided in favor of the homeowner in that case, who confronted the police, whom he didn't know were police, armed with a shotgun. I mean, so those are the kinds of decisions that side with the individual, with the homeowner, instead of the government, that we need to fight for those decisions to remain good law. And that is what is in danger here, because to put it in context, there was this really awful Fourth Circuit decision in 2017 called United States versus Robinson. And if you really want to raise your blood pressure, you can go read that case. And I think I've put it on my blog before, but U.S. versus Robinson was a challenge to the Maryland assault weapon ban. And again, Maryland is in the Fourth Circuit. It's not an open carry case. It's not a free state at all. And so they had passed an assault weapons ban, and that was challenged, and it went up to the Fourth Circuit. And I believe it was defeated the first go around. But remember when I was talking about you have a panel decision and then you can have an en banc decision. Well, after the panel decision, the government then petitioned for a rehearing en banc with all the judges. And now what happened is, as a whole, the Fourth Circuit sided with the government, finding that the assault weapons ban in Maryland was constitutional and was legal. And read that case. It'll teach you a lot about the state of so-called Second Amendment rights in America right now. And they discussed that, look, the Supreme Court of the United States has not found yet that there is a right to even have an AR-15 in your home, much less outside of your home. So therefore, there is no Second Amendment right to possess an AR-15 in Maryland. And then they go into gutting U.S. versus Black. So Judge Gregory issued a dissent in U.S. versus Robinson because he was the author of U.S. versus Black, and that decision gutted a lot of U.S. versus Black. And he explains in his dissent why they shouldn't do what they're doing. And I think I have some of it here. Okay, so in Judge Black's dissent in U.S. versus Robinson, and I'm sorry, there was another Fourth Circuit case that I'm talking about was the Maryland assault weapons ban. That's an awful decision. Robinson was a different one. I'm confusing the two, but I've put these on my blog before. This one, Robinson, had to do with guns in a car, and it gutted Black to the extent that if a police officer sees even a legally possessed gun even in a legal state, an open carry state, he's allowed to disarm that individual during that traffic stop. Now, the difference is, and again, that's United States versus Robinson 2017. It's been a long day. The difference is that they discussed was that, all right, you already have a forced encounter. Well, they call it a forced encounter between law enforcement and the citizen. And so in U.S. versus Black, in our case, our issue is reasonable suspicion. So that's the legal standard to stop in the first place. So the difference is once you're in a car in a traffic stop, you've already passed that point. So there was already other reasons. It's usually all right. I'm back. I'm not sure what happened there. Should be working. Is it working? I should be smoking a cigar anyways right now. I haven't even eaten dinner yet. I've been writing about guns and obsessing about it, gun rights, all day. So I'm almost done. What I was saying was Judge Gregory in the dissent of United States versus Robinson. That means that was the part where he disagrees with the other judges, but he was on the losing side. He specifically mentions West Virginia, and that's why it's so important to us. And he said that, in my view, the Fourth Amendment doesn't allow for, a regime in which the safety risks of a policy like we have in West Virginia can be, where the police can selectively and discretionary spot check and frisk, certain legally armed citizens, even if they're already in a traffic stop that was legally justified based on some BS traffic violation. So he even disagreed with that. I mean, that is the type of federal judge that you want ruling on your civil rights. And so he specifically mentions West Virginia in this. And he says that's particularly true for West Virginia because we don't require that people carrying firearms even inform police that we have guns during traffic stops or any other stop, even if they ask. So where a state has decided that gun owners have a right to carry concealed guns without telling the police about them, that we gun owners should not be subjected to frisks because they stand on their rights. So where a sovereign state has made the judgment that its citizens safely may arm themselves in public, he said, I do not believe that we may presume that public gun possession gives rise to a reasonable suspicion of dangerousness, no matter what the neighborhood. So again, that's United States versus Robinson. That's Judge Gregory's dissent. And that basically totally gutted the vehicle occupancy side of U.S. versus Black. So even in West Virginia, where we live in a free state, we have great gun rights. according to federal law, if we're armed in the car, police officers can disarm us. Or, you know, the holding of United States versus Black doesn't apply. So they don't have to have any other suspicion of criminal activity. They can just assume that if you have a gun, you might be a criminal. I need to disarm you, do a background check, and so forth. Still, the law in West Virginia and in Virginia and in North Carolina is that if you're on foot and you have a firearm, they can't just assume because you have a firearm that you're probably engaged in criminal activity. And that protects all of us. But here we have Putnam County, West Virginia, trying to change that. And in their view, law enforcement should be able to ID anybody anytime they want, run their background check. If they see a guy with a gun, you're getting a background check. And that's what that deputy said. He said it, you know, he said he does it every day. So that's the importance of the Walker versus Putnam County case. And again, I've been asked for lots of updates on this, and it just takes time to go through the process, but that's where it is. We've been working on it behind the scenes. Our brief is going to be filed tomorrow. I'll post a copy of it. And at some point, hopefully we'll have some oral arguments on it. And let's pray that, you know, we get Judge Gregory on the panel, which would be great. And because it's about his own decision not being followed by the lower court. So I will, you know, do hopefully some more updates in the future, and check out the blog site where this stuff will be posted, the civilrightslawyer.com. And I will see you next time. Thanks for watching. And somewhere I have my little video here. Where is it? All right. Follow the guidelines also. Follow the guidelines.